Hi, my name is Manny Vacchiano. For the last 20 years, I've been a practicing biotech patent attorney. And during that time, I also have invested in biopharma companies. About 5 years ago, I left my in-house biotech company position and I started a private practice. And at that time, I also formed AMP Biotech Research, where I lead a team of graduate student consultants who help me to research biopharma companies. Today, I want to talk about the AMRN ANDA litigation. An ANDA litigation or an ANDA litigation is a generic drug litigation. It's a special type of patent litigation. Today, I'm going to talk specifically about key considerations in that litigation for biopharma investors. With my experience, I think I bring a deep and unique perspective on this litigation. Now, there have been quite a few lessons I've learned over the years as a biopharma investor. And a few of those lessons that I think are particularly noteworthy with respect to this litigation are: first, to be as objective as possible in assessing the risk of catalyst events. Catalyst events, as you know as biopharma investors, are typically clinical trial readouts. Well, in the case of this litigation, the catalyst events are actually events that occurred during the litigation. And the lesson still holds that we have to be objective as we look at these events and these catalyst events. One is to understand our biases, because we all have biases. I personally am biopharma bullish. It's my bias. Many of you are probably bullish biased in biopharma stocks, so we've got to be careful that we're still objective despite our positive viewpoint on biopharma. And secondly, we all have ego and greed as underlying factors within us that we've got to control to make sure that they don't eclipse the facts and don't bring us into a subjective instead of an objective analysis of a catalyst event. In addition to being as objective as possible, we also need to be knowledgeable about these catalyst events. We need to understand them if we want to trade stock before or after the catalyst events to try to make money on the event. Now, specifically with respect to the AMRN ANDA litigation, the one thing that I have noticed is that retail investors are very opinionated about this litigation. That is probably at least partially because investors like myself lost a lot of money when the district judge ruled against AMRN in the litigation district court ruling about near the end of March. And so there are frequent postings on retail investor sites about the litigation. And one thing I want to do is warn you about legal conclusions that I see in these postings on sites like Seeking Alpha and Twitter, because I see a number of times where these conclusions are incorrect. This is very complex from a patent law perspective, very complex from a litigation procedural perspective, and very complex from a regulatory perspective. So I warn you about posts that you see, not to trade on these posts unless you really do your diligence and understand that you have this correct. Also, many of these retail investing posts attack the district court judge. And again, that's understandable. We lost a lot of money. We're not happy with that ruling. But the fact is that the district court judge carefully analyzed the facts, understood at least a vast majority of the facts, and generally understands patent law. You can see that from her 70-page brief. And I say this and feel this way even though the Federal Circuit might reverse her decision on obviousness. Now, there are a lot of factual rulings that she made, and I would say, as I mentioned, the vast majority of her factual rulings are correct. Now, I'm not saying that the appellate court, what we call the Federal Circuit, won't find one or two of those key rulings clearly erroneous, but the fact is that she generally applied complex facts to the law correctly. Now, I want to talk about a few obvious facts about the litigation. One is clear from the stock price chart of AMRN shown here. The district court ruling hugely affected the AMRN stock price. You can see in late March, I think the stock dropped by like 75% the day of that ruling. And another fact is that this appeal that's ongoing, the decision in the appeal is very likely to affect AMRN's stock price in a big way. If AMRN wins, their stock price will likely increase by at least 3 times. If they lose, their stock price will likely decrease by at least 25%, maybe 33% or more. Another obvious fact is that prior art obviousness, from a legal analysis perspective, it's very complex. And especially in cases where you have a known drug and a new use and lots of prior art considerations, this can be a very subjective analysis for investors, but especially for judges as well. And that's something that's important to realize. So what are your choices as an investor in considering this AMRN litigation? One is that you can stay out of AMRN stock until after the litigation. That's a reasonable decision. This is very complex. You likely don't understand the details, and so you can stay out of the stock until after the litigation and then get back in. Another approach is to stay in the stock as a long-term investor and conclude that, sure, there are things I don't understand about this litigation, and it's likely to drive the stock up or down, but I think even if AMRN loses the litigation, their valuation currently is still low enough that I should make money in the long term because of the rest of world market and in a market where they would compete with generics in the US. So you can stay in the AMRN stock, and that's a reasonable decision as well for investors. And another opportunity, which I'm trying to give you through this AMP subscription, is that you can become knowledgeable about the litigation as it unfolds from an experienced patent attorney, from my viewpoint. So you have 3 choices there. Now let's look at the possible catalyst events, at least some of them, in this litigation. And I'm showing our AMP, what we call AMP cards, which we publish for catalyst events. And for the AMRN ANDA litigation, the next key event is the filing of the response brief by the defendants, the generic company defendants, which is going to happen on June 16th. I'm recording this video a few days before that event. And if you subscribe to our service, I'll give you my viewpoint on whether that event will affect the stock price. But that's the next event. And if we look at other upcoming events in the litigation, we've got, and we look back on May 12th, AMRN filed their appeal brief. As I mentioned, we've got the June 16th generic company response brief due. On June 26th, AMRN's reply brief is due. On July 1st, there's a joint appendix due from the parties. And then the first week of probably September or October, we'll have oral arguments in front of the Federal Circuit panel that is appointed for this case. And then finally, there'll be a decision, a ruling, either late this year or early next year. So all of these are possible catalyst events. And if you become a premium subscriber, I will, in addition, give you at least one additional event that you probably are not aware of that is a catalyst event that actually might be one of the most important catalyst events in the litigation. And secondly, there's prior data in our subscription service. We'll make the key briefs readily available to you. So next up is this generic company reply or response brief in the appeal process. But if we take a step back and say, well, what happens in the litigation after the appellate panel rules? What happens after this late 2020, early 2021 Federal Circuit ruling? Well, if AMRN loses, then they will try to get a rehearing by the Federal Circuit, by the en banc Federal Circuit. So in this appeal, they're going to have a panel of 3 judges review the case. But if they lose, they'll likely try to either get a rehearing from the whole Federal Circuit, all the active judges. I believe there are 12 active judges, or really, they might try to get the Supreme Court to hear the case. Both of these are unlikely scenarios because they are not granted that often. An en banc ruling and also a Federal Circuit, a Supreme Court certiorari grant, they're not very frequent. So it's unlikely if AMRN loses that it will get an en banc decision or a Supreme Court reconsideration, but it is possible, and there are at least one fundamental kind of issue here that could be ripe for one of these procedures, but it's unlikely. Now, if AMRN wins the appeal, the litigation is not over. This will go back to the district court. The district court will find or rule that the generics infringe the patents if they launch their products, because the district court judge ruled in favor of AMRN with respect to the infringement, induced infringement analysis. So what will then happen is the generics will then appeal this, and it'll go back to the Federal Circuit now on an appeal from the generics with respect to the induced infringement issue. Anyway, this is the likely scenario if AMRN wins. And of course, settlement is possible at any time. So what should an investor understand about this ANDA litigation? Well, as I mentioned, what and when are the catalyst events during the appeal process? And I just took you through the timing of those events. And as I mentioned, there's at least one additional event that you're almost certainly not aware of that we disclose to our subscribers. Secondly, as these events unfold, how do they affect AMRN's chances? And in the subscription, I will give you my viewpoint before and after and as these events unfold. And then what are the chances of settlement at the various points in the litigation? What are the chances of a preliminary injunction filing and the success of this filing from AMRN? AMRN announced back when the district court ruling was announced that they would file a preliminary injunction if the generics were approved and then launched. Well, Hikma got approved. As of this recording, they have not launched. And thus far, AMRN has not filed a preliminary injunction motion, but we have a brief in the subscription service where I discuss in depth the likelihood of AMRN winning if they file a preliminary injunction motion in this case. It's a complex issue. And then another fact that you should be aware of is, are there other intellectual property options for AMRN that would allow them to block the generics outside of the specific patents that have been asserted in this ANDA litigation? These are some of the patents that are associated with AMRN's initial indication in severe triglycerides. Severe triglycerides. So these are just a few of the patents that AMRN owns that are asserted in this litigation. But AMRN has lots of other patents that we've begun to dig into. And so another question that we all should ask is, does AMRN have another option to potentially block the generics, even if they lose this appeal and lose this litigation? These are some thoughts about the litigation, the timing of the litigation, that I hope you'll find valuable. I also want to tell you about what I see as the most common error made by retail investors, probably all investors, many investors, and it was also an error that arguably AMRN's trial counsel made, which is reliance on the reduced trial to conclude that the asserted patents in this litigation are valid. Now, the reduced trial was a seminal trial, no question about it. The problem is that the asserted patents in this litigation are directed to methods to treat patients with severely high triglycerides, like triglycerides of at least 500 mg per deciliter, whereas the reduced trial involved recruiting patients with high triglycerides of at least 150 mg per deciliter, not very high triglycerides. And the AMRN's trial counsel, in their briefs, made a lot of arguments of why the reduced trial helps to establish the validity of these AMRN patents as a key factor in what we call these objective indicia or secondary indicia of obviousness. But the fact is, in the district court, in her ruling, went into great length to explain why the reduced trial really doesn't matter in this situation much. And that is a place where obviousness law, which, as I mentioned, is quite complex, and in fact, in some ways, in the appellate court split procedurally, but the bottom line is it is clear that the patents and the scope of the claims of the patents have to be consistent with whatever facts AMRN would use to try to prove that the patents are valid in this sort of as objective indicia, like the reduced trial. So you'll see in the AMRN appeal brief very few, maybe one or two mentions of the reduced trial. And I think that shows that AMRN, their appellate counsel feels differently about the reduced trial, and the district court judge, really did a good job of explaining why the reduced trial really doesn't matter in this litigation. So the next time you see a post by a retail investor who says, this is, Vascepa is a groundbreaking drug and therefore these patents are valid, look at the reduced trial. Well, unfortunately, the reduced trial really doesn't matter much for these patents. It may be unfair. Sometimes patent law is unfair, but that is the way it plays out here. I don't want to say that AMRN has no chance to win the appeal, because I think they do have a chance to win the appeal, but it's not going to be because of the reduced trial, in my viewpoint. So let's summarize some things here in some closing comments. This AMRN ANDA litigation involves complex patent law, litigation procedural issues, and regulatory issues, in addition to the complex scientific and technical issues. The appeal outcome will likely affect AMRN's stock price in a big way. The district court judge's ruling was well reasoned. It was detailed, even though it might get overturned. If AMRN wins the appeal, this litigation is not over. And the reduced trial really doesn't matter much for this current litigation. So I want to conclude by discussing our subscription service. You could be in the know about this AMRN appeal process. I am a retail investor myself, and I have a place in my heart for retail investors. And so we're making this subscription available to you where you can get my viewpoints, my comments along the way. You will know when impactful events will occur, including one event that you almost certainly don't know about in this litigation that could be extremely impactful. You'll know how these events, as they unfold, affect AMRN's chances of success in the appeal process. And you'll know whether AMRN might have other intellectual property that they could bring to bear on the generics. At least we're looking through a bunch of the AMRN patents, and we plan to talk about at least some of those and whether or not AMRN could bring those to bear here. We're still doing the analysis ourselves. So we've got a number of current articles up for subscribers. One's on the preliminary injunction, possibility and chances of success. One's on an amicus brief that was filed by the Bio organization, which is interesting, and it talks about a current split in the appellate court with respect to obviousness procedural analysis. And then there was a kind of an unusual, unexpected article by the primary investigator in the reduced trial, Dr. Bott, who basically published an article that really attacked the district court judge's ruling. And I talk about that and what is the significance or not of that article with respect to this litigation. So there's 3 articles up already with over, I think they're valued at over $1,000. And the bottom line is we've priced this for retail investors. And we're running specials at various times, but this is priced in the hundreds of dollars, this subscription. And I've already put in, and with my PhD, patent agent, law clerk, tens of thousands of dollars of billable time into this. So you're getting that for hundreds of dollars a month. And it comes with a 14-day free trial. You can cancel it at any time. And your subscription, look, it helps me to keep looking at AMRN and other situations like this for retail investors, because I really would love to level the playing field for those investors that really can't afford their own private biotech patent attorney like myself on an hourly basis. So I hope you'll subscribe, and we provide the link there on the slide. So to conclude, I really hope that you've learned some things about the AMRN ANDA litigation through this slide deck. There are some other free presentations and articles that we've put up on our website about the litigation. And of course, I hope you'll become a subscriber and you can really have me at your side throughout this litigation process to understand it as key events unfold and to understand key events that you probably, at least one of which you're not aware of currently. Thanks, and whatever you decide, best of luck in your investing in biopharma companies.